Yes.
So we had completed, I think, I'm happy to say, our look at the authorities relevant to ground one, as well as some points that I would make relying on them, submissions on their application, how they apply to some of the things that our friend has said. And I'm going to, for the rest of ground one and my submissions on it, look at the transcript a bit. And how some of those principles apply. If we could start with the evidence of the questions of the appellant. If I may, I want to start with the questions of Miss Eva Camaro, because the first point that I invite you to derive from the transcript is that in terms of the first, if you like, we call it the first of Mr. Justice Ousley's factors, namely whether it's a sort of peripheral point that's being sort of sprung or within what's been said, you'll see, and I won't go through all of it because of the time we've got, and ultimately there's some 9 pages of Miss Eva Camaro's questions, but just to sort of sketch out the sort of terrain that she maps in her questions.
Yes.
So we're on page 79 of the bundle.
Yes.
And she starts at line 19, did you check various colleges? How did you pick that one? There's some exploration of that. And then at 33, do you recall roughly how many people were present? And I should also add that I don't know how much experience my lord and my ladies have of these ETS cases, but they do follow certain standard area questions that to essentially trained on assessing whether the teasing out the point about whether this individual sat the test they said they did. Which goes to the question about what was foreseeable and or otherwise. And then on page 80 at 13, did you recognise anyone when you were there? 16, did you attend with anyone else? You see the mention of Mr. Islam at 21. And then Eva Camaro moves on to the 60-day letter. And what he did in response, that's on page 81. And she moves back at 34 to the process after his speaking test at 34.
Sorry, line 34.
Line 34,
yes.
Questions about whether there was anything, this is on 82 at 14, was there anything that made you think that the
Sorry, page 82.
Page 82, line 14, was there anything that made you think the way they recorded your score was incorrect? Well-travelled ground, basically in this area, and then at 84, other employment. At 84 at 18 about contacting Jones Day about the recordings, and at 28, page 84, still a letter to Queensway College and the manner of that contact. And I won't go through it all, much as it's sort of tempting to do so, but if we move on to the judge, who begins at page 87, and start, I mean, just from the start, and I'm afraid this is just going to be indicative, and I'd simply invite my lord and my ladies, if you reserve judgment, that is, when you look at this, that it is possible ultimately to trace each of these questions back to areas of questioning by Miss Eva Camaro. And even if some aren't sort of perfectly preceded, well, that's inevitable, because ultimately, as I said before, why would you be asking the same question? What we see in this context, what we see in this transcript, owing to the context which I mentioned, namely these ETS cases concerning the same issues, is that we do in fact see not just not peripheral questions, but in fact almost the same sort of questions, because it's such well-travelled ground. So starting with where did you live at that time, at line 18, well, you saw effectively the same area of questions out on page 79, lines 27 and 30. line 24 on this page, 87. Which other colleges did you look at? Page 79, line 29. How long did it take you to reach the college? That's line 29. That's back on 79 at line 27. As to why did Mr. Islam go with you, that slightly at an angle perhaps, but it arises from what Miss Eva Kamara elicited about the appellant having gone with Mr. Islam. So ultimately that, I would submit, is what you will find by reading it through. I mean, just to take another on page 89 at line 7, when did you find out about the allegation of deception? We see sort of foreshadowed on page 80 at line 29. Page 89 within the judge's questions at line 19, did you contact the college, Queensway? Well, we know, and she probably knew that he did, because that was elicited by Miss Eva Kamara, but it begins her springboard, if you like, into questions about that. She seeks to achieve greater specificity, ultimately. She says, you contacted Queensway, tell me the date. That's line 21. So ultimately it is explored, because the judge for this first instance tribunal was required ultimately to have sufficient evidence, because without it, that too is potentially an error of law. And we see something similar in relation to Mr. Islam. His questioning by Miss Eva Kamara begins on page 94.
Yes.
She asks how they met, where they met for the first time, whether they studied together, and whether he had done an ETS test, whether they lived together, how they travelled to the test together. That's on 96. When they arrived, it's all, as I sort of said when we were still on the authorities, these questions ultimately map the terrain of questions. They cover everything. Clearly, I would infer that, although I don't know Miss Eva Kamara, that she's done these cases before, and they follow a pattern of how you came to choose that college, ultimately all to test the reality of it, whether he actually picked it for a real reason or someone else sat the test. The ground is traversed, and then the judge asks questions beginning on page 'It's actually for Mr. Islam. There's no heading of there's no heading of questions by the judge, which makes things harder in this case. But I think it begins on 99 after.
Well, I think it might start on page 97, because if you look at line 28, any re-examination,
Yes.
and then there's nowhere it starts.
27, line 30. 30. No, I think it's 30.
Well, that looks like it.
30.
Line 30.
Line 30.
Just trying to help Tom. Sorry if I'm not.
So line 30 on
Page 97.
With who is his cousin?
Yeah, who is his cousin?
Yes.
Yes.
Yes. That is my note. Sorry, that I have here. Question by the judge. Heading should be here exactly.
Yeah.
And we can see that arises from lines 24, 25, talking about we like to borrow some, need some money, but his cousin is. And we see on 98 at 11, why did Mr. Hossain choose Queensway College? Do you know, 25, do you know when he contacted the college, or did he contact the college? I mean, none of it, I'm not sure the questions before you that we've sort of flagged up from the authorities are answered by perfect granular pairing questions from each area of question, but it does, I hope, show that they are all within the bounds of anticipated questions and within an area already elicited by cross-examination. It's also clear from all of this, that all these questions, that there was only ever politeness to the witnesses and to the advocates, and as I said before, that the extent of questioning is significantly less than the questions by Miss Eva Kamara. And that is ultimately it, really. And that is sort of essentially taking seriously and engaging with the submissions, but even the submissions, I would say, aren't capable of reaching the thresholds that we've identified this morning, because they are very far from the mischief that we see in the cases.
Sorry to interrupt, Mr. Gawai. Can I just check one point?
Yeah.
The advocate who appeared on behalf of the Secretary of State,
Yes.
she's referred to as Eva Kamara in the transcript, but the determination of the FTT refers to her as Ms. Selva Kumaran. Presumably, that's on page 128.
Yes.
Presumably, that's the right name, isn't it? Rather than Eva Kumaran.
I'd have to check, my lady. I hadn't even spotted that.
Because it looks from the transcript as though the transcriber made a guess
Right.
at the name of the
Yes.
advocate.
Yes, you see lots of that. For instance,
Yeah.
TOEIC is
Yeah.
spelt all sorts of ways. Yeah.
Yeah. So I think if you look,
Yes,
you
apologies.
see right at the very beginning
Yep.
on the cover sheet,
Yes. 128.
question mark,
Oh, I see.
on page 77,
Yeah.
the cover sheet of the transcript. So I just wanted to check. But it seems like you can't help
Yes.
what the correct name is.
I absolutely accept that. Happy to, if I refer to her as Selva Kumara. Yeah. So I think that is all I need to say on how they apply. I mean, even in the permission grant by Lady Justice Andrews, she narrowed the ambit of your inquiry by saying that we're not talking about this sort of interruption of cross-examination line of cases. This is purely about supplementary. So that narrows it, and then it's not really seriously argued that there was any hostility, despite some of the tone my learned friend adopted in reading bits of the transcript. And so we're then just left with, are these questions arising out of or sprung from left field? Well, I would submit that they're not, but query whether that would, well, they simply aren't. And quantity, I mean, clearly the quantity is not beyond the sort of ratio Mr. Justice Ousley had in mind. That is really as much as you need from the facts. The knockout, if you like, although unfortunately we are looking at this substantively, is that because of the seriousness with which fair hearings must be taken, are sufficient. The authorities show that these submissions can't reach the relevant threshold, but the facts confirm that. Unless my Lord Ladies have questions on ground one, I could have gone to ground two.
Nothing? No, thank you. Yes.
Thank you, my Lord. So, ground two, I'd like to start with how this ground is put, and in particular within the skeleton argument. So if I could take you to the bundle at 26.
Yes.
So paragraph 39. Judge Gleeson erred in law by relying upon the fact that the appellant's counsel who appeared before the FTTJ did not object to the FTTJ's conduct. 42.
Would you mind completing the reading?
Well, we can read it. Don't worry about it.
Yes, I mean, I don't propose to read each paragraph, but please do read the whole surrounding words.
Yeah, thank you.
42. Perhaps I'll read them all. It follows that the fact an appellant did not confront a first instance judge with the argument that she rendered a hearing unfair by departing from a proper function is of, at most, very limited relevance.
Yes.
43. It cannot be directly relevant to the objective evaluation called for in this context, as that is a matter of law for the appeal court and fairness, but it's relevance that I'm relying on.
Right.
44, it's submitted that in this context, the fact that an appellant did not confront a first instance judge with an objection to the judge's conduct can therefore only be relevant where the appeal court or tribunal is required to establish the factual matrix against which the objective evaluation of the fairness of the hearing falls to be considered. 46, lastly, in this instant case, in the light of the transcript of the hearing in the first tier tribunal, the upper tribunal had a reliable record of that hearing and was required to assess the fairness of the hearing in the light of it. In this context, and bearing in mind Mr. Karim's evidence, there was no sound basis upon which the UT could make an inference of relevant fact based on Mr. Karim's decision not to challenge the tribunal judge directly. Now, the point is, this is saying that this wasn't a relevant consideration. It wasn't relevant that Mr. Karim didn't say anything, object, protest, comment. That's plainly wrong. First of all, if I could, well, if it doesn't bind you in any way, Lady Justice Andrews, in her permission to appeal order, page 1 of your bundle.
Yes. Which paragraph?
I think it's paragraph 2.
Yes.
She says, failure by counsel instructed at a hearing to protest to the judge about the judge's extensive questioning of the appellant and his supporting witnesses was undoubtedly a factor that the upper tribunal was entitled to take into account when considering if procedural fairness had been established. And then the point she says that would be wrong was if you treated it as determinative.
Yes.
But that's not the case that's been put. It's been, as we've seen from the skeleton argument, it's been said that it wasn't relevant. Plainly was.
I'm not sure that, to be fair to Mr. Biggs, that he's saying it's completely irrelevant in the those passages in the skeleton argument. He's saying it can only be given limited relevance. Limited weight.
Which particular paragraph?
Well, for
do you have in mind,
example,
Lily?
paragraph 42 is of at most very limited relevance. He's not saying, I don't think he's saying it's completely irrelevant. And again, at 45, will be at most very limited.
Yes. Yes, but well, there's a difference between extent of relevance still and whether something is and the weight to be attributed to it and whether it's dispositive or not. To say that it is it's not relevant or it's only of limited relevance is ultimately to contest the extent to which it may be taken into account.
Yes,
there's no concession.
Yes, but in a different way, because if you're saying it's of limited relevance, then you are conceding that it can be or could be taken into account.
Perhaps we're reading the skeleton differently, my lady. I mean, I totally concede, as for instance, the third of the quotes I read out, it was put in terms of it cannot be directly relevant. So maybe there's a sort of adverb of that makes it unclear what's being put. But I didn't read this as saying that it's fine to take this into account, but it's only one factor amongst many, which is what I would accept.
Right, okay.
But to turn on to why Mr. Karim's non-interference was given specific consideration by Judge Gleeson, rather than rely purely on the transcript. It's ultimately because it was relied upon by the appellant, who adduced his witness statement at the appeal stage, because presumably otherwise it would be said, well, couldn't you have said something? So given that, the upper tribunal was entitled to make a finding on the significance of that non-interference. It wasn't, as we can see from the judgment at 45, page 51 of the bundle, the sole extent of the upper tribunal's consideration of that issue. Judge Gleeson says there, considered the first tier's questioning broadly and from multiple angles, beginning with a careful reading of the transcript, quote. So if we go to that, it might be. You have that. A careful reading of the transcript shows the judge did ask many questions. No indication did so in an aggressive manner. And notes the fact that the advocates were given a chance to ask further questions. I mean, that paragraph just wouldn't be there if it were determinative simply that Mr. Karim hadn't said anything. Those are all relevant considerations. I take the point that the wording of 48 once reached, particularly because of it appears just before 49, where, well, just of its own account, the final sentence on 48, if there was no procedural unfairness, if there had been, Mr. Karim would have not hesitated to say so at the hearing. With the colon, for instance, it sort of looks like some sort of logical inexorability, but we see from the broader judgment that it wasn't the only factor in there, and it's not possible to read this as saying as something that would have treated as sufficient without all that had gone before in a fairly detailed judgment. My own friend's taken you to Bezic already and to PA, two cases that ultimately treat it as not just relevant but of significance. So even if it's a question of directly relevant or limited relevance or whatever, those are cases which have said that it's significantly relevant. And that is what has gone on that is how it's been approached by Upper Tribunal Judge. And I would pick up on or endorse my Lord's point about the duty point. If there were no question of duty, then perhaps there'd be all sorts of reasons why something wasn't said. As Lady Justice Laing says, you don't really know why. It might have been fear, it's up to the point where you can't rely on it. But where there is the presence of that duty, and we see in the sort of some of the cases about the advocate effectively being prevented from doing their job, prevented from asking questions. And that is relevant because ultimately, subject to being prevented from doing your job, you're ultimately able and responsible ethically to your client to speak up. And therefore when such comment or criticism is missing, it's a notable absence for that reason. So relevant consideration and treated as such and as no more than such. Those are our submissions on ground 2. So I can help you any further. I finished a lot sooner than I envisaged. Ground 2 is less to be said.
Yeah. No. Thank you very much. Thank you, Mr. Torrey. Yes, Mr. Biggs.
Thank you, my Lord. I think I can be very brief as well. I'm grateful to my learned friend for his submissions. On the XS and JK cases, I took the court to them, and my learned friend took the court to them. I think, though, there's a danger in the way that my learned friend relies on those authorities, and it's this. Mr. Justice Ousley did not seem to be concerned with the Jones principle. I don't think he refers to Jones in terms, and he certainly is not setting down rigid guidelines or principles. as to how Jones it falls to be applied in the immigration appeal context. But as we saw earlier in my respectful submission, there's actually nothing in those two judgments that undermines the appellant's argument. The questioning in this case, we respectfully submit, did go beyond what was envisaged by Mr. Justice Ousley in those cases. Now, my learned friend's submission.
Sorry, Mr. Biggs, just so I can understand your submission, are you submitting that because Mr. Justice Ousley didn't refer to Jones, we should ignore what he had to say, or are you not?
No, I'm simply ringing a note of caution about those cases, insofar as my learned friend relies upon them as a sort of canonical formulation of what is and what is not appropriate. Not questioning the First-Tier Tribunal as against the Jones principle. That, in my submission, would not be an appropriate way to approach those cases, because the Tribunal was not concerned, the Tribunal was not concerned in those cases with the application of the Jones principle. And more fundamentally...
But surely, even if Mr. Justice Ousley didn't refer to Jones, those are the sorts of considerations he had in mind, aren't they?
Yes, I mean, and the Tribunal was entitled, and certainly Mr. Justice Ousley, the President, was entitled to give a general steer or general guidance. And you've heard my submission.
Yeah.
The guidance that the learned judge gives is not incompatible with our submissions. But I'm simply ringing a note of caution. It does not seem, in my respectful submission, that Mr. Justice Ousley was looking at setting down bright line rules or clear guidelines even in respect of the Jones principle. And the overarching point here is that the Jones principle, as I think my learned friend accepts, is a fact-sensitive general principle. So its application is fact-sensitive because it's a general principle. So one has to look at all the nuance and detail in a given case.
Well, if you don't mind, if I might just test that. Hold on a second. Here we go. If you go to paragraph 35 of JK, please.
Which is
Oh, it's tab
JK 17.
Tab 17, page 334
Thank you, my lord.
of the bundle. And the complaint or the ground of appeal was, the first complaint, this is how it's referred to in the judgment, paragraph 18, relates to interventions during the appellant's evidence.
Yes.
So it is interventions. And then if you go to paragraph 35, in that, reference is made to what the this must be the tribunal's judgment. Then you see in the middle of paragraph 60 there's a sentence that starts, I did not agree with Mr. Bob and pointed out that it was far fairer to allow the appellant an opportunity to explain matters that concerned me in this evidence. Now that's the adjudicator's assessment, and that is approved by Mr. Justice Ousley at the end of paragraph 42.
Yes.
So is that not a, I mean, we're not talking about bright lines, we're just talking about, as has been said, just pointers to when it might be the wrong side of the line and when it might be the right side of the line. Not bright lines, but just a line. So that's when the judge went on in paragraph 43, highly legitimate for the adjudicator to ask his or her questions on issues of inconsistency or matters which trouble the adjudicator, whether or not they are raised by the other party.
Yes.
I mean, is that a? I mean, you're not saying that's not an observation which is accurate as a matter of law, are you?
We don't say that.
No.
And I'm simply, I'm responding to how I perceived my learned friend to argue his case by reference to these authorities, which at least to some degree seem to extend to the proposition that these guidelines are fairly firm. I certainly accept what my law puts to me, that what's said in paragraph 43 and 44 is compatible with the application of Jones.
Right, thank you.
And in fairness, I should also make this clear on reflection. I mean, if we look at paragraph 41, at the bottom of 335.
Sorry, hold on. The bottom of 41.
Bottom of 335, paragraph 41.
Yes.
Although Jones is not referred to, or any of the authorities on Jones type unfairness, it's pretty clear that Mr. Morgan, who was appearing then, I think, for the appellant, was arguing something like Jones unfairness. That seems to be what's said in the first sentence of 41, because it's contrasted with apparent bias.
Yes, yes.
So I think it's a fair criticism to put to me that
not a criticism,
well,
it's a question.
I think it's fair to point out that Mr. Justice Ousley had in mind unfairness of a trial in the Jones sense, at least broadly speaking.
Yes, yeah.
Our submission, though, is that paragraphs 42 and 44 are compatible with our argument as to why the learned judge in the first tier tribunal went the wrong side of the Jones line. And but care should be taken not to treat these as some sort of canonical bright line rules, because that would be incompatible with the need for an objective, fact-sensitive evaluation. That's really all I'm trying to say. I hope that's reasonably clear.
Thank you.
I think the XS case might have been more concerned with apparent bias, but maybe I'm wrong about that. And this brings me to perhaps the most important point in reply, that there potentially is a difference between the parties as to what the essential principle here is. In my submission, the essential principle in respect of Jones' unfairness is concerned with the proper role of a judge. The judge's proper role is as an independent referee or adjudicator. And if the judge descends into the arena by pursuing questioning when that's unnecessary, when it's not needed in order to clarify information, and when the judge pursues their own line of questioning, then the judge departs from that proper function, or their proper function. And the unfairness that then arises is the risk that the judge will be unable to detach themselves, if you like, from the fray, from the dust of conflict, and conduct an objective evaluation of the issues and the evidence. That is the unfairness that arises in a Jones case. Now, my learned friend put the point in terms of a party being deprived of a meaningful opportunity to put their case. And that, in my submission, is not correct. He also relied on the need to show unfairness.
Well, sorry to interrupt, Mr. Speaker. In some cases, if a party is deprived of a meaningful opportunity to put his or her case, that will amount to unfairness in the Jones sense.
I'm grateful. That's absolutely right. And this, so if you like,
I thought that's what you meant. I just wanted to.
I'm very grateful. This is the distinction between pages 63 and 64 of Jones and 65 of Jones that I sought to draw out right at the beginning of my submissions in opening. So at 63 and 64, Lord Denning sets out the basic test, which is about the proper role of the judge and not descending into the fray and having one's eyesight blinded by the dust of conflict or whatever metaphor, not donning the robe of the advocate. And then at 65, Lord Denning points out that there's a particular risk of that happening in respect of interference with cross-examination.
Yeah.
And in that context in particular, the unfairness arises because a party has been unduly hampered, improperly, if you like, hampered in the presentation of their case.
Yeah. So you're saying the principle is not restricted to that, that's just an illustration?
Yes. Yeah. And my learned friends focus on the cross-examination cases, and the way he put his case by reference to being denied a meaningful opportunity for a party to put their case as a result of judicial interventions, in my respectful submission, risks losing sight of the true nature of that overarching principle.
But sorry, can I just? I think I got lost there. Your essential principle, I understand. But then you went on. The unfairness that arises is the risk of something happening.
So
and it's coming back to your point that it doesn't need to actually happen. It's enough just to have a risk of it happening. Is that your submission or not?
It is, and that exactly that's the point I was coming on to make. So the other difficulty with my learning friend's argument as a matter of basic principle here is that he argues that there needs to be some form of unfairness, but he doesn't explain with great respect what the unfairness is. The unfairness in these Jones cases, in my submission, is the risk that the judge will be unable to complete their task. The proper role of a judge is to objectively evaluate the evidence and the issues. And the difficulty that arises where a judge descends into the fray is that they may subconsciously disable themselves or risk disabling themselves from that function. So that's why, that's the species, if you like, of unfairness that arises in these Jones cases. That is, in my submission, what Lord Justice Jonathan Parker has in mind in the Kofi Adu case, at paragraph 146 that we spent some time looking at earlier, and which is referred to in the other cases, including in Seraphim.
Then I think you have to deal with what is said in paragraph 59 in Keane.
Yes, and I did say something about that in opening, but I'm very grateful to go back to it now. So that's on page...
It's page 37.
I'm very grateful. Behind tab 2.
Yes.
Now, I think the court has the submission that I made by reference to the Seraphim case. I think it was paragraph 44 from memory in Seraphim, where the G case is referred to. And the point that's made by the Supreme Court there, Lord Wilson's judgment for the court there, is that even if you have a perfect determination, perfect, well-written judgment that seems to get everything right, that doesn't cure the unfairness.
No, if there has been unfairness.
Exactly.
But if there has been unfairness, not a risk of unfairness.
Yes. But the unfairness is in the risk. I mean, otherwise, what does unfairness mean?
Well, it means the trial has been unfair. Or the hearing has been unfair.
But in what sense, my lord? I mean, we're going around in circles, perhaps.
No, you can't further define it. It either is a fair hearing, as you said, is an objective assessment.
Yes.
That is susceptible only to one proper answer, namely that it is unfair or isn't unfair.
Yes.
And the reason I asked you to address this is that this is, it's in effect two Court of Appeal decisions to the effect that excessive interventions, which on your submission have created a risk of the judge being unable to complete his or her task properly,
yes,
isn't enough to establish unfairness. You've got to establish unfairness, not just a risk of unfairness.
Well, I'm not sure that is what is being decided in these cases. We looked at paragraph 59 in opening, and my learned friend referred to it. And my submission in opening was at the end of paragraph 59 on page 37. Was that this passage is not incompatible with the unfairness arising by virtue of risk. What's happening here is that the court is looking at the overall circumstances and forming a holistic judgment. So this passage can be squared with the proposition that the risk hasn't reached the required threshold if, having careful regard to the real issues and how the judge's conduct impacted on them, indicates that the judge was still able to objectively discharge their function.
And how would you describe the threshold? If it had, the risk hasn't reached the required threshold in that context, how
Well,
would you?
that, I think, is a matter of feel and impression for a court applying the objective assessment that has to be undertaken.
No, but threshold to what? Is the threshold, the risk hasn't reached the required threshold of what?
The risk is that the judge would be subconsciously or otherwise unable to complete their function as a judge of objectively evaluating the issues and the evidence.
So if I was to write down risk hasn't reached the required threshold, this may not be completely accurate, to mean that the judge is not able to complete their task properly.
The required threshold of risk. I mean, so what the court is not in Kofi Adu at 146. The court is not saying that the judge has to be disabled from objectively judging the case. What the court is saying in that passage is that there has to be a sufficient risk of that happening, and that is what makes the proceeding unfair. And the difficulty with the different approach of just looking at fairness in some broad sense is, I think, the problem of circularity. What is it that makes the proceedings unfair? In my submission, what makes the proceedings unfair in this context is the judge descending into the arena with the consequence that they're unable or potentially unable of objectively judging the case. And it can't be right to look in every case where a Jones argument is made at whether actually the judge in fact was able to objectively evaluate the evidence. That would be impossible for a court to determine, in my respectful submission. And it's impossible to reconcile with the observation in Seraphim at 44, for example, by reference to the G case, that you can have a well-produced judgment or decision, and that doesn't cure the unfairness. In other words, I suppose we are dealing here still with procedural unfairness and not substantive unfairness. And the procedural unfairness that's arisen is that the judge has departed from their proper role. Now, I think my learned friend also relied on paragraph 66. I think my lord would want to put that passage to me. The ultimate question is whether the judge's interventions made the trial unfair.
Yes.
And then in this decision, by reference to Kofi Adu and Seraphim, the court concluded that looking at everything in the round, there was no unfairness. In my submission, though, the difficulty here is we still don't know what the unfairness is that the court is saying didn't arise if it isn't what I am submitting, if it isn't the objective unfairness of a judge descending into the role of an advocate. Now, even if I'm wrong about that, and you need to show that somehow the findings or the outcome of the proceedings are to some degree unreliable, as I try to explain in opening, there is a clear indication that that is what happened in this case. Because the judge's analysis of the evidence focused very largely on the answers that were given to her own questions, and there are flaws in that analysis, as I tried to point out during the course of opening. So this is a case where there are real indicators that the judge was actually unable to, if you like, detach themselves from the fray and complete the task of objectively judging the case reliably. So if you like, that's my fallback submission. If you do have to look at something, whether the decision is sort of substantively unfair to some degree, or there's some broader conception of fairness at work here as well.
As against that, you rely on Seraphim for the proposition that the judgment may look wonderful, but that's not the test.
Exactly, and I'm sorry if I'm not being as helpful as I could be. I'm trying to get at what is the unfairness here, and how one determines that. And often when one drills down to the very bedrock of principle, it's quite difficult to articulate the principle. But my lady, I absolutely agree with you, and I've referred to paragraph 44 a few times. I think that's where the point is made. Yeah. And I say again, and this is the final time I'll say it, if it isn't that sort of unfairness, procedural unfairness in the sense that the judge has just got departed from their proper role with the risks that that entails, albeit that you need to have enough on the evidence to show that that risk is real or substantial. Maybe that's the point. It needs to be a real or substantial risk. It's not just a fanciful risk. There has to be a certain threshold. But once you get to that, then the fairness is established.
If you were sort of, as it were, pushed into a corner, metaphorically, would you submit that what the judge did here, so if you just leave your risk test on one side, would you submit that what she did here went too far in any event?
Yes.
Just to check.
I'm grateful. I mean, when one looks at the judge's evaluation of the evidence, and we looked at it in opening, and compares that to the questions and answers in respect to the judge's questions of the witnesses, you can see that the learned judge has got too close to things, and that has affected the learned judge's evaluation. And I gave some examples of how that can be seen, with evidence not being addressed in terms, with some degree of inaccuracy in the way the judge records her findings.
I think you also pointed to one or two passages where the judge did appear to be cross-examining.
Yes, yes. That's part of the overall evaluation, but I'm not sure that could answer the sort of suggestion there has to be some degree of substantive undermining of the fact-finding or something like that.
No, but I we're leaving that answer to one side.
Yes. I mean, our overarching, so I think there's two stages here. There's the objective evaluation of what happened, and we respectfully submit that the judge, with great respect, went too far because the judge pursued questioning that was unnecessary and in all the circumstances, bearing in mind the transcript and Mr. Carey's evidence, demonstrated that the judge did, if you like, don the robe of an advocate, contrary to Jones. And an aspect of that is the way the questions were asked, leading questions, but also the fact that so many questions were asked, also the fact that these were questions that were exploring issues that really didn't need to be explored, and I'll come on to that in a moment. But then you get to the issue of, well, what sort of unfairness do we really need to demonstrate? Do you need to show that the judge's ultimate conclusions and findings were in some way undermined, so there's some degree of substance as well as process, and you've got my submissions about that.
Yeah.
I don't think we need to go that far, but if we do, this is a case where you can see that the judge's findings are to some degree undermined.
Yeah, so that's as it were a fallback submission.
Yes, it is. I'm very grateful. My learned friend also says that there's a conflict here between fairness and justice. In my submission, that's a false dichotomy. If the proceedings are fair, then justice will be served. And our system does expect, with great respect, that judges stay within the proper ambit of their role. And that is how justice is achieved. Penultimate point, as I understood one line of argument my learned friend developed, he effectively argued that because the questioning the judge pursued flowed out of cross-examination, that in some way undermines the appellant's argument. Well, there are 2 points in response. Firstly, we don't accept that that is what happened. The judge pursued lines of inquiry that clearly commended themselves to the judge. They were the judge's own lines of inquiry. But even if we're wrong about that, what my learned friend's submission amounts to is the contention that a judge can properly discharge their role as an objective referee of the issues by picking up the baton that is passed by an advocate for one party and then running with it by pursuing extensive questioning that the advocate for one of the parties chose not to pursue. That, in my submission, is simply incompatible with the proper role of a judge. So far from undermining the appellant's argument, the fact that the judge seems to have done that, at least to some degree, strongly supports the appellant's case. And the final point, just on ground 2, I'm very grateful to my lady. We don't submit in the skeleton argument or orally that the fact that an advocate did not make a contemporaneous objection to a judge's conduct is irrelevant. what we do submit is that in the context of a Jones unfairness case, that fact is of limited relevance. It's of, as we put it in the skeleton argument, indirect relevance, because the court's function is to objectively assess whether there was the requisite unfairness. And so the relevance of that fact, the absence of an intervention, is in informing the factual matrix against which that objective evaluation has to be undertaken. And that's how we put it in the skeleton argument. And in this case, because one, there's a transcript, and two, there was evidence from the advocate who didn't object, explaining why they didn't object at the time, the relevance of the mere fact of the absence of an objection was very limited. And the real submission, drawing all of that together in respect of ground 2, is paragraph 51 of the skeleton argument. It follows that the upper tribunal erred by placing significant reliance on the advocate's professional decision, that's a quote from the witness statement, not to object to the judge's questioning. More particularly, the upper tribunal judge erred by relying on her view that there was no procedural unfairness because if there had been, Mr. Karim would have objected. That's a submission I developed earlier. And in my submission, that argument must be right. Looking at paragraph 48, my learned friend relies on paragraph 45 to say, well, the judge wouldn't have looked at the transcript if she was basing her decision on the absence of an objection. But that's not a good argument, with great respect. The judge did look at the transcript, but her essential point as to why the questioning did not cross the line was that there was no objection. And that indicated that there was no unfairness. So at the very least, the learned judge erred by placing substantial reliance on the absence of a contemporaneous objection by my predecessor. And as we submitted earlier, that conclusion, that inference was not open to the judge. The inference that had the advocate below been concerned about unfairness, he would have objected. Even that inference wasn't open to the judge because the advocate had explained their thinking. And there was no proper basis, with great respect to the upper tribunal, to just brush that evidence aside and reach a conclusion that flew in the face of it. So those are 2 points there, really. The judge erred by placing too much weight, perhaps dispositive weight, on the absence of an objection when evaluating whether the Jones unfairness had been established. And secondly, the inference that the judge made, no objection, therefore advocate didn't think there was unfairness, was not open to the judge because it flew in the face of what the advocate explained in his signed witness statement without any evidential foundation. My ladies, my lord, those are my submissions, unless you have any questions.
Anything? No, anything?
I just wanted to check. So the transcript was available for the hearing. Yes, because that
It was.
That in the observation that appears from the last bit of paragraph 44, didn't it? It was.
It was. And I mean, my learned friend.
It looks as though it must have arrived quite late, though, which is why you had a witness statement.
I think. I think the documents show what happened. Initially, there wasn't a transcript. Initially, Mr. Karim settled grounds of appeal. Home Office then raised an objection. Mr. Karim formed a professional judgment that he wouldn't be able to appear because there was some issue of fact, and he produced a witness statement.
Yeah.
I think that those two things may have come in a different order, but they're related. And then the transcript was available by the time of the hearing. And it was because the statement went in that I was instructed effectively, rather than advocate in the first-tier tribunal. My learned friend argues that the advocate's evidence was given sort of central prominence in the arguments below. With respect, it wasn't. It was part of the picture. The judge was concerned about there being no objection, so the evidence was relied upon to deal with that. But it was the transcript which was at the centre of our arguments, then as it was now, as with great respect you would expect.
Yeah.
Thank you, my lady.
Thank you. Thank you. Thank you both very much for your comprehensive and very helpful submissions. We will reserve our judgments. When they're available in draft, they will be provided to you in the usual way for the restricted purposes for which they are sent to you. In other words, just to correct typographical errors. And we would hope that once you've received the judgments, you'll be able to agree a draft order, but if not, we'll agree with outstanding matters on paper. So thank you again, and for completing your submissions so well in good time. Thank you.